Dear students, viewers and the subscribers, welcome to the IAS Mentor. This would be our lecture number 32 in the series Indian Polity, and we are gradually progressing every day by every lecture, covering every concept, and in this way we'll complete the entire subject Indian Polity probably in another say a couple of months or maybe a little more than that. So that is how we are planning to cover the entire subject. And I'm very sure that by the time we complete this particular series, that it will be a very good resource for the students preparing for UPSC IAS examination. And not just the UPSC IAS examination, but also for the students preparing for other competitive examination, including various state public service examinations where Indian polity is a subject. So with that, we'll get into the topic that we want to discuss today. In the last lecture, we are trying to understand Article 21 of the Constitution, where we are trying to understand the concept of right to life and personal liberty. And we understood that the right to life, or for that matter, the personal liberty, they're all rights guaranteed under Article 21, but they're not absolute rights, and they can be restricted in accordance with what is called as the procedure established by law. That is what the Constitution reads. But however, the Supreme Court, post the Maneka Gandhi case, has said that if at all the right to life and liberty is to be deprived, how it shall be deprived? It shall be deprived in accordance with what is called as the due process of law. Or in other words, applying the principle of due process of law, the right to life and liberty can be deprived. And in the last class, we are trying to understand basically the difference between what is procedure established by law and the due process of law. Now, what do you understand by procedure established by law? So, procedure established by law will only see certain things, whether there is a law in the first place. It will see whether the enactment of the law has happened properly, and the enactment has happened properly, and that law provides for a certain procedure as to how to deprive the right to life and liberty, and whether that procedure has been followed as it is laid down in the law by the enforcement authorities. So, these are the things that the procedure established by law would allow the judiciary to verify. If somebody challenges any action of the state on the ground that their right to life and liberty has been deprived. But the biggest problem with this particular doctrine, procedure established by law, is that it is not allowing the judiciary to see whether the procedure is a just procedure, whether the law or the subject matter on which the law is dealing with, is it fair enough, or it is just enough, or it is reasonable, whether the procedure laid down in the law is following the principle of natural justice or not. These are all beyond the scope of the doctrine what is called as procedure established by law. And that is when the Supreme Court in the Maneka Gandhi case said that henceforth the doctrine or the principle that has to be applied in verifying whether the right to life and liberty is to be deprived, what shall be followed is what is called as the due process of law. So that means we will not only check whether there is a law, whether the procedure laid down in the law has been followed properly or not, but we will also see whether the procedure that is laid down in the law is a just law, whether the procedure laid down in the law is whether it's a just procedure, whether it is a fair procedure, whether it is a reasonable procedure or not, and thereby changing the doctrine to from procedure established by law to what is called as due process of law. And this is basically what you'll have to understand. And to put it in one single word, by this change brought in by the judiciary, now the judiciary can not only question the executive action, but they can also question and they can also review what is called as a legislative action. Basically, the law and the subject matter can also be questioned on its justness and fairness, not necessarily that the implementation which is done by the executives. So both the legislative action and the executive actions are subject to judicial review, can be questioned on justness and fairness in order to protect the right to life and liberty of an individual under Article 21 of the Constitution. So that's basically the simplest way of understanding as to what is due process of law and how is it different from what is called as the doctrine of procedure established by law. But however, this doctrine that was innovated or brought in by the Supreme Court, because it is not explicitly mentioned in the Constitution, it is rather a judicial innovation. This judicial innovation that is brought in by the judiciary has brought in a lot of changes with regard to the rights that is to be implied under Article 21 of the Constitution. Because it is in this particular case, that is in the Maneka Gandhi case, the Supreme Court has given a wider and a very liberal interpretation to the concept of as to what is life, what is right to life or personal liberty. In fact, they said right to life is not a mere animal existence, but it is a right to have a meaningful and a dignified life. And right to personal liberty is not mere restriction from arbitrary arrest or detention, but rather it should allow an individual as a part of his liberty to do whatever one wants to do as a free man that would bring him happiness. So thereby it is giving a very liberal interpretation to the concept of what is called as liberty as well. And henceforth after 1978, by applying the interpretation of what was given by the Supreme Court in the Maneka Gandhi case, the Supreme Court in number of judgments have said a number of rights to be implied under Article 21 of the Constitution, although they are not explicitly mentioned in the Constitution itself. The Supreme Court said to have right to life or personal liberty, these are all the rights which is implied, and otherwise the individuals will not be able to exercise what is called as a right to life and liberty. In this way, the Supreme Court has said a number of rights to be implied under Article 21 of the Constitution, and we are going to understand some of those rights which the Supreme Court has said that they are implied under Article 21 of the Constitution. And one such important right that I am going to discuss today in the first lecture or in the first part or probably in the entire class is what is called as the right to privacy. And right to privacy was declared to be a fundamental right implied under Article 21 of the Constitution by the Supreme Court in 2017. A historic judgment was given by the Supreme Court in the year 2017, which is also called as Justice K.S. Puttaswamy case. In this, a constitutional bench sat over the matter to decide whether the right to privacy is a right implied under Article 21 of the Constitution, and the constitutional bench was satisfied with a view that yes, right to privacy is implied under Article 21 of the Constitution. What does it mean by a constitutional bench? Usually, a constitutional bench are those benches which are constituted in the Supreme Court when they hear a particular case. Normally, it is dealing with an important matter related to the Constitution or interpreting the Constitution. So normally, usually 5 or more judges sit to decide such matters. But however, if you see this Justice Puttaswamy case, because it will have a lot of implication upon how the legal system is to be governed in our country, there are 9 judges who are brought part of this particular case. And those 9 judges, ultimately, the majority opinion declared that yes, there exists something which is called as right to privacy, which is implied under Article 21 of the Constitution. So today, as we'll proceed, we'll try to decode as to what is this right to privacy, what the Supreme Court has said about right to privacy, what could be the possible implications of this right to privacy. So these are all the things that we'll discuss as we'll proceed further. But the first thing that I wanted to bring it to your attention is what is the historical background behind this right to privacy? How was this matter brought to the Supreme Court? In fact, Justice Puttaswamy case in 2017 was not the first case where there was a discussion on right to privacy. Even before the Puttaswamy case, there were a number of cases, and to be very specific, couple of cases has come to the Supreme Court where the same matter was argued in front of the Supreme Court that there is something which is called as right to privacy under Article 21 of the Constitution, which has not been accepted by the Supreme Court. The Supreme Court did not view that there exists something which is called as right to privacy implied under Article 21 of the Constitution. But however, when the government came out with the Aadhaar project, you basically know that the Aadhaar project allowed the government to collect certain sensitive information of the individuals, of the citizens. Especially they can collect not only the demographic information, but they can also collect what is called as a biometric information. Our fingerprints or the iris scans, which are very unique to an individual. And these biometric informations are also part of what is called as this Aadhaar. So this Aadhaar project of the government was challenged in the Supreme Court by Justice K.S. Puttaswamy, challenging that collecting these information could allow the state to have some kind of surveillance on the citizens, and having these information itself is a violation of what is called as right to privacy. So therefore, it can infringe on their right to privacy. Now, this is exactly the matter that the Supreme Court has to decide whether the Aadhaar project violates the right to privacy of an individual. But however, to decide this particular petition, first they have to decide whether there exists right to privacy or not. Unless and until there exists right to privacy in the first place, how can it be argued that yes, the Aadhaar project could be violative of right to privacy? So first the Supreme Court has to decide, in order to decide the validity of the Aadhaar project, whether there exists what is called as right to privacy, and hence the Supreme Court first decided on what is called as right to privacy. And does it exist under Article 21 of the Constitution? Where the Supreme Court was convinced, yes, there exists something which is called as right to privacy. Now, what was the reason for the Supreme Court to decide there exists what is called as right to privacy? The Supreme Court was basically convinced, yes, there exists something which is called as right to privacy because of the following reasons. In fact, if you go back a little, we'll try to understand. If you go back a little in the history, in 1978, in the Maneka Gandhi case, the Supreme Court said right to life is not a mere animal existence, but right to life is nothing but right to have a dignified human life, a respectful human life. So anything that would prevent an individual from having a dignified life can be seen as what is called as violation of their right to privacy, violation of their right to life. This is basically the argument that was put forward. Now the question is there any relation between dignity and the privacy of an individual? So you'd have to understand as to what is privacy. So privacy means there are certain things which are very personal to an individual. There are all certain things which is part of the personal affairs of an individual, where it does not allow unwarranted intrusion by any of the others, including the state or including any of the other private individuals. And if others unnecessarily intrude into our personal area or personal sphere, then we can say that to be violation of our right to privacy. So now the question is every individual is required to have certain element of privacy, and will that privacy helps an individual to have a dignified life? Say for example, the relationship that we have in our life is a very personal matter, and there is no need to others to know about all those things. And in case if they come to know, and if there is some kind of publicity and all these things, it may have an impact on the dignity of an individual. Say for example, the personal information is very much personal to each of us. So sharing our personal information with others may have an impact upon the dignity of an individual. So therefore, the Supreme Court was very convinced that the right to privacy is very much related to what is called as, or otherwise privacy is very much related to what is called as dignity. Already it is very clear that right to life includes what is called as a right to have a dignified life. So to that extent, if an individual is to have a dignified life, every individual should have certain sphere of what is called as privacy. And if this privacy, or if there is any unwarranted intrusion into the privacy or the domain of privacy of an individual, then it can automatically have an impact upon what is called as a dignity. So the Supreme Court was convinced in the Justice Puttaswamy case that unless and until an individual has privacy, an individual will not be able to have what is called as a dignified life. And therefore the Supreme Court was convinced privacy is integral to the dignity of an individual. So therefore right to privacy is implied under Article 21 of the Constitution. So after Justice Puttaswamy case, the Supreme Court made it very clear that right to privacy is implied under Article 21, though it is not explicitly mentioned in the Constitution. Because without right to privacy, it may be difficult for an individual to have what is called as a dignified life. So now the question is, what is privacy? So privacy is that right to be let alone, or it is right of every individual to have their own private sphere from which they shall be protected from any form of unnecessary or unwanted intrusion by the state or any of the other private entities. In fact, the Supreme Court has gone a little further, and they tried to explain as to what could be the possible dimensions of right to privacy, where could be the applications of right to privacy. For which the Supreme Court also said that they have not dealt elaborately, but they have given some examples as to what could be the various possible dimensions of right to privacy. So in fact, the Supreme Court said that some of the dimensions of right to privacy include, first of all, what is called as a data privacy. When I talk of data privacy, the Supreme Court was convinced that every individual do have what is called as a personal data. And what do you understand by personal data? A data based on which an individual can be identified. So such data are called as personal data. Say for example, the name of an individual is a personal data, the mobile number of an individual is a personal data, date of birth of an individual is a personal data. So first of all, right to privacy would cover what is called as a data protection, the personal data protection of an individual. So that is not in public domain. Others cannot misuse these data, even if an individual shares his data with others on the basis of a trust. So the first dimension of right to privacy is what is called as data privacy. And the second dimensions, examples of privacy, is what is called as bodily integrity or bodily autonomy of an individual. Bodily integrity means that every individual shall have the right over their body, that what they are supposed to do with their body. Say, for example, the kind of medical treatment or the procedures that they may undergo. So, the kind of decisions that they take with their body. Say, for example, the reproductive rights of an individual. So, these are all part of the bodily integrity, which also includes the right of a woman to go for abortion or not to abort a child. That's basically, although that right to privacy is not an absolute right. You'll have to understand from that dimension. It may be regulated by a law. But however, yes, the bodily integrity would mean that these are all various applications of bodily integrity, that what they can do with their body. Probably, as I already said, the medical procedures, medical treatment, the health procedures that they can take care. So these are all examples of what is called as bodily integrity. And apart from that, the Supreme Court also said that right to privacy would also include an aspect of what is called as decisional autonomy, the choices or the decisions that we make in our life, which has a personal implication upon us. Say, for example, the right to marry a person of one's choice, or for that matter, the sexual orientation of an individual. So, what kind of sexual orientation one might have? One might have a heterosexual orientation, one might have a homosexual orientation. These are all part of right to privacy. So in fact, this right to privacy has a very direct implication upon another section, that is section 377 of IPC, which also deals with what is called as lesbian, gay, bisexuals and transgenders sexual orientation, which has been now decriminalized. The very basis of section 377 of IPC to be read down by the Supreme Court is because of what is called as right to privacy. I'll make the link a little later as we'll proceed. So right now we are discussing the right to privacy. So some of the dimensions of right to privacy includes all these things. The data protection of an individual, the personal data protection of an individual, the bodily integrity of an individual, the decisional autonomy of an individual. In fact, the Supreme Court also said that it also includes protection from state surveillance, unnecessary state surveillance. So these are all some of the dimensions of what is called as right to privacy. So basically, right to privacy means what? Right to privacy means that the individual should be protected from unnecessary or unwanted intrusion into their private sphere. Not necessarily only by the state, even by the private entities or the authorities. That is what the Supreme Court said. But however, as the other fundamental rights, the Supreme Court has also made it very clear that right to privacy is not an absolute right. So right to privacy may be restricted. And how it shall be restricted? It shall be restricted on a reasonable manner, because it is again implied under Article 21 of the Constitution. Article 21 of the Constitution says that the right to life and personal liberty of an individual can be restricted in accordance with the due process of law. So following that, any law can be made where the law allows for a just law, where the law is a just law and it allows for a just procedure based on which the right to life and liberty can also be restricted. That means basically a law should be there, and that law can provide for a reasonable or a just procedure, and based on which the right to life liberty, which also includes the right to privacy in this case, can also be restricted. That is a basic understanding you should have. So if we have an understanding as right to privacy is an absolute right, that is not the right idea. Right to privacy is definitely there, but it can be restricted by a reasonable law, by following a reasonable procedure. So that is what you'll have to understand. In fact, after this judgment was passed by the Supreme Court, the Supreme Court has directed the government to appoint a committee and to study as to how the personal data of an individual can be protected. And then subsequent to this particular direction, the government has appointed a committee to study as to how to protect the personal data of an individual. And according to which the committee has also given the report. So based on which recently the government of India has enacted what is called as a Digital Data Protection Act 2023. And if you see the Digital Data Protection Act, the main intention of this Digital Data Protection Act is to protect what? Is to protect what is called as the personal data of an individual. In fact, people who are misusing the personal data of others, there are provisions for punishing those individuals. So this is basically the idea of this Digital Data Protection Act. In fact, today we share a lot of information with various companies on a fiduciary capacity on the basis of trust. So for example, whenever we download an application, probably we'll have to give some of our personal information, but that information should not be misused. And that information can be used only for the purpose for which it is collected. So these are all the things that is regulated under the Digital Data Protection Act. So this is basically the view that you should have with regard to the right to privacy. And today the right to privacy is very much implied under Article 21. But however, the right to privacy is yet to see its application completely, because we do not know to what areas the right to privacy will apply. And already we are seeing the applications of right to privacy in number of areas. And one such area is the decriminalization of Section 377 of IPC. Not just decriminalization of Section 377 of IPC, even decriminalization of the offense of adultery, that is Section 497 of IPC. Today, adultery is no longer a punishable offense. Adultery is no longer a criminal offense. I hope the students might know as to what is the meaning of adultery. For those who are not aware of the meaning of adultery, it was a colonial law in our country, which we continued for a long period of time. But in 2018, the Supreme Court in Joseph Shine case has declared that adultery is no longer a punishable offense. What is adultery? Adultery is basically sexual orientation or sexual intercourse outside the marriage. So that would amount to, I am putting it in a very simple words. Sexual intercourse outside the marriage is basically considered to be what is called as adultery. And that law was found to be violative of various fundamental rights, because the Supreme Court found that that law was basically discriminatory. Section 497 of IPC is discriminatory. But above all, one of the most important aspect of why the Supreme Court has decriminalized adultery today is because of the fact that they found that it is part of the privacy of an individual as to their personal relationship. So the state cannot make unnecessary intrusion into the decisions of an individual and the personal relationship of an individual as to with whom they wanted to have personal relationship. So these are all the various applications and dimensions of right to privacy which will keep evolving over a period of time. Today, right to privacy has a lot of applications on the abortion rights of the women. Right to privacy tomorrow may have implications upon what kind of treatment one have to undergo or should not undergo. It may be part of their bodily integrity. So while this will keep expanding over a period of time, but there are few things that we may have to consider at this point of stage is the data protection, which is very, very important. And that is for this particular reason, the government has enacted what is called as the Digital Data Protection Act 2023. But another area, as I already said, where the application have also gone is that decriminalization of Section 377 of IPC, which is again part of the right to privacy of an individual. It was part of what is called as the decisional autonomy of an individual. So let me also brief you as to what is the Section 377 of IPC for the students who are not having an idea about it. In fact, Section 377 of IPC was again a colonial law. Section 377 of IPC has made, as a part of this particular law, it has criminalized what is called as lesbian, gay, bisexuals and transgender sexual orientation. So all these forms of sexual orientation or sexual intercourse is a punishable offense under Section 377 of IPC, because the lesbian, gay, bisexuals and transgender sexual orientation is considered to be sex against the order of nature. So that's a basic premise on which this law has been made, sex against order of nature. That means this is not something that the nature accepts. And hence anybody who is engaging in all these forms of sexual orientation, lesbian, gay, bisexuals or transgenders, now these are all not the sexual orientation which is normally accepted by the society, that goes against the norms of the society, and hence these forms of sexual orientation or people who engage in these forms of sexual orientation should be punished under the law. That's the idea of the Section 377, and this continued to be a law for a long period of time. In 2010, this was challenged in this particular provision was challenged in the Delhi High Court. The Delhi High Court gave a historic verdict that the Delhi High Court has said that they have to somehow not have this particular view of criminalizing the lesbian, gay, bisexuals and transgenders. In fact, the Delhi High Court did not take everything, because the petition was not challenging everything, but the Delhi High Court gave some relief to the gay sexual orientation. Because the Delhi High Court is of the opinion that the sexual orientation is beyond the control of an individual. It should not be seen against the order of nature. There is nothing against the order of nature. Rather, it is a personal choice of an individual, and the individuals may not have control over the type of sexual orientation. It is only a deviant behavior, but it is not something against the order of nature. Any deviant behavior than what normally the people will do cannot be seen as against the order of the nature, and hence it should not be punished. Or the gay sexual orientation, or the people who involve in such sexual orientation, should not be punished under the law. So the Delhi High Court decriminalized partially the section 377 of IPC. What was decriminalized by the Delhi High Court was again challenged in the Supreme Court of India. In the year 2013, the Supreme Court of India has not taken a similar view as it was taken by the Delhi High Court, and the Supreme Court of India has recriminalized LGBT, and they said that section 377 would continue to be a punishable offence. If at all LGBT is to be decriminalized, the legislature is free. The parliament can make a law, they can amend this particular provision, but the judiciary is not going to change this. So that is what has been told by the Supreme Court. So what has been decriminalized by the Delhi High Court has been again recriminalized by the Supreme Court. So the matter did not have any development after that till the time the Puttaswamy judgment came in 2017. Now just try to recollect what happened in the Puttaswamy case. In 2017, Justice Puttaswamy case, when it was heard, the Supreme Court said that the right to life includes what is called as right to privacy. So right to privacy is part of the right to life and liberty. And one of the aspects of right to privacy is also what is called as decisional autonomy. And decisional autonomy also includes the type of sexual orientation an individual can have. So now the basic question, after the Puttaswamy case was brought in, the basic question that was again brought into the Supreme Court in 2018. So try to understand. Post the Puttaswamy case, again a matter was brought to the Supreme Court. Now they asked, in the Puttaswamy case, the Supreme Court has already said that right to privacy is part of what? Right to privacy is part of Article 21, and right to privacy also covers what is called as the sexual orientation or the decisional autonomy of an individual, which covers what is called as a sexual orientation. So when you say that the decisional autonomy is part of right to privacy and the sexual orientation is part of the decisional autonomy of an individual, so does it mean that you will punish an individual for exercising his fundamental right? Will you punish an individual for exercising his sexual orientation, which is part of his right to privacy, which is part of his decisional autonomy? So basically this was brought to the notice of the Supreme Court in 2018 in a case which was called as the Navdeep Singh Johar case. On careful consideration, the Supreme Court thought that yes, section 377 of IPC is conflicting with what is called as the right to privacy of an individual, and therefore it is going against the decisional autonomy of an individual, which also includes the sexual orientation of an individual. In fact, the Supreme Court is of the view, what is the role of the state if an individual is having a type of sexual orientation? And in fact, it is part of his private life. To whom an individual is having a sexual orientation or what is his nature of sexual orientation is none of the business of the state, because it is perfectly or it is completely part of the private life of an individual. So the state has nothing to do in these things. So state should not intervene or intrude into the personal aspect of an individual, which is part of his right to privacy. And to that extent, the Supreme Court has partially, I would say, read down section 377 of IPC. Even today, section 377 of IPC continues to be part of the statute, but however, not in the same form. To the extent that it was found to be violative of the fundamental right, it has been read down. So the Supreme Court said that if any consenting adults and if they are engaging in any form of sexual orientation in private, it has nothing to do with the state. The state has no business in entering and seeing as to what is the nature of a sexual orientation of an individual. That is completely part of the right to privacy of an individual. But however, yes, if the sexual orientation is happening not on the basis of consensus, or even on the basis of consensus, if it is happening between an adult and a minor, and if a sexual orientation is happening in the form of what is called as bestiality, which also means sexual orientation between humans and animals. Now, all these things would continue to be a punishable offense even today. But however, sexual orientation between two consenting adults in private is no longer a punishable offense because it is perfectly part of their right to privacy. So, this is what the Supreme Court has told in this particular case. So, to that extent, the right to privacy has a lot of implications upon a lot of other rights which people would continue to exercise over a period of time, and that's why it becomes very, very important part of your understanding also. So I'm quite sure as to what is your understanding of right to privacy and what are the reason as to the Supreme Court said that right to privacy is implied under Article 21 of the Constitution. What are the various dimensions of right to privacy and probably the other applications of right to privacy will keep evolving over a period of time. But this is the basic understanding you should have with regard to what is called as right to privacy. Now with that, I'll move to the next application of this Article 21 of the Constitution, which is also the evolution of what is called as euthanasia in India. So let us also try to understand as to what exactly is this euthanasia. I'm sure that most of the students might have heard about the concept of euthanasia, but today I'm going to deal with that in detail and we'll try to understand as to what is the position of euthanasia right now in our country. But before I get into euthanasia, what do you mean by euthanasia? Now, euthanasia is nothing but medically or through medical procedures legally terminating the life of patients, and that's basically what is called as euthanasia. That doesn't mean that we can terminate the life of the doctors can terminate the life of all the patients. No. The patients who have entered into what is called as a persistent vegetative state or a permanent vegetative state, or somebody who is declared brain dead, or somebody who is, there is medically no possibility that their position can be reversed. And once a team of doctors certify that a patient has entered into a persistent vegetative state, then they will not be able to lead a life with dignity. So there is no way that they can take care of themselves. And for the rest of the life, although they may be alive, it is seen as a life without any dignity. And to that extent, the Supreme Court has allowed to carry out what is called as euthanasia, or in other words, what is called as medically terminating the life of the patients who are in a permanently vegetative state. So that's basically what is called as euthanasia. So euthanasia means medically terminating the life of patients under certain circumstances. That is basically what is called as euthanasia. So right now in our country, we do not have a law related to euthanasia, but today euthanasia is carried out in India based on the directions that is given by the Supreme Court. And one such important case that you'll have to keep in your mind is the Aruna Shanbaug case, which I'm going to discuss within a few minutes. But before we get into Aruna Shanbaug case, if you broadly divide euthanasia, the euthanasia across the world can be broadly divided into two types. One is active euthanasia and other is what is called as passive euthanasia. So what do you understand by active euthanasia or passive euthanasia? If you see, active euthanasia means in both the cases the life of the patients are taken away who are in a permanent vegetative state. So if you see, the difference between active euthanasia and passive euthanasia is merely it is procedural difference, nothing more than that. What is active euthanasia? In active euthanasia, the medical team will actively administer something into the body of the patient. So thereby the life of the patient is brought to an end. Say for example, in active euthanasia, they may inject a lethal injection into the body of the patients, and therefore the life of the patient might be brought to an end. That is basically what is called as active euthanasia. Whereas in passive euthanasia, the doctors do not do actively something, but they remain passive to the needs of the patients, or the medical team remain passive to the needs of the patients, and that's basically what is called as passive euthanasia. Say for example, if the support system, the oxygen support system is over, probably they fail to replace that, they don't replace that, so they are passive to the needs of the patient, so thereby bringing the life of the patient to an end. And that's basically what is called as passive euthanasia. So when you cut off the life support system, or when you cut off the treatment that you do to the patient, so therefore their life can be brought to an end. That is actually what is called as passive euthanasia. Whereas active euthanasia is something that actively that is administered to the patient. So therefore the life of the patient is brought to an end. It may not be the cutting of the life support system, but probably you don't continue with the treatment. Suppose you'll have to give some medicine so that the life of the patient is kept alive. So you cut off giving that particular medicine. So therefore the life of the patient is brought to an end. And that's basically what is called as passive euthanasia. What is recognized in India and what is allowed in India as per the Supreme Court ruling is only what is called as passive euthanasia. The courts has not recognized active euthanasia. Although some of the countries across the world, they also practice what is called as active euthanasia, but that is not legal in India. What is legal in India is only passive euthanasia. But there's a story behind as to how this passive euthanasia was legalized in our country, for which we'll have to go to what is called as the Aruna Shanbaug case, a very historic case that happened in 2011. And for which we'll have to understand who is this Aruna Shanbaug. Aruna Shanbaug was a nurse who was working in a hospital in Mumbai. But unfortunately, when she was working in her hospital, in the hospital itself, she was strangulated by one of the ward boy. And the reasons are not very well known, but for some reason she was strangulated and she was physically assaulted by the ward boy in the same hospital. But unfortunately, nobody has taken notice of what has happened. Nobody has taken notice of this event. And unfortunately, after she was strangulated and she was physically assaulted, and because of the strangulation that cut off the oxygen supply to her brain, and for which she has become unconscious. And all these things has happened in a private room in the hospital. So others were also not aware of this for a long time. Maybe as per the sources, it is say for around 15 to 20 hours, nobody was aware of these incident. And then probably when they came to know, Aruna Shanbaug was already unconscious. And although she was unconscious, she was alive. And then the medical staffs in the hospital, they took care of her. But unfortunately for Aruna Shanbaug case, this incident happened in 1973 when this assault was happened. But unfortunately for Aruna Shanbaug case, for the next 42 years, that she continued to be in the state of coma. Her coma has never reversed, although she was alive, and she continued to be in the coma for a long period of time. And that is when a public interest litigation was filed in the Supreme Court that the life that Aruna Shanbaug is living is not a dignified life. So right to life includes what is called as right to live a dignified life, but the life that she is leading is not a dignified life. So the court should give permission to medically terminate the life of Aruna Shanbaug because she is already living in what is called as a persistent vegetative state or a permanent vegetative state where she is not able to take care of herself. And that is not a dignified life, and an individual cannot live a life which is undignified for a long period of time. So with the permission of the court should allow to carry out what is called as euthanasia on Aruna Shanbaug. And to that extent, a public interest litigation was filed. So what is this public interest litigation? Public interest litigation means any individual can file a case, not necessarily the affected individual, but any individual on the interest of the general public or on the interest of others who are going through some suffering or certain other things, they can also bring it to the notice of the public just because they have an interest towards others in the society. These are all people who are public spirited in nature. And to that extent, they filed that particular petition. So in this case, Aruna Shanbaug did not file this case, nor her relatives. In fact, Aruna Shanbaug had nobody to take care of her except for the hospital staffs. Their family members were not alive at that point of time, and she had no one to take care of her. Only the staff members in the hospital were taking care of her. But some unrelated person has filed a public interest litigation and brought this to the notice of the court. The court looked into clearly, and the court was convinced that yes, the state of affairs of Aruna Shanbaug is really unfortunate, and we do understand that she is leading an undignified life. So euthanasia may be administered, but on certain conditions. So what are the conditions that was put forward by the Supreme Court? The Supreme Court said henceforth that if euthanasia is to be administered, only what type of euthanasia can be administered in India is what is called as passive euthanasia. And any individual who wanted to administer euthanasia on their relatives or on themselves, they can approach the High Court concern in their respective state, and they can take the permission from the High Court and they can carry out what is called as euthanasia. But however, before administering euthanasia upon an individual, first a medical team of doctors, a board of doctors has to be administered. They have to review the condition of the patient. They have to certify that there's no possibility that the patient's status can be revived. And apart from that, it has should also be approved by the family members of the patient. If the patient is in a state of coma, then the family members have to give permission to carry out what is called as passive euthanasia. If there are no family members to the particular patient, then the friends of the friends or any of the other caretakers have to probably give the permission. And by following all these procedures, the court has accepted or the court has given the approval to carry out what is called as passive euthanasia. So for the first time, euthanasia became a reality in India, and that too, that is passive euthanasia in the Aruna Shanbaug case. But however, in this case, for Aruna Shanbaug, the euthanasia was not carried out because the staff members in the hospital, they did not give permission. They said that as long as Aruna Shanbaug is alive, we'll take care of her. So we are not going to give permission to carry out euthanasia on Aruna Shanbaug. Few years later, Aruna Shanbaug had a natural death because of multiple organ failure. She died. But however, passive euthanasia was recognized by the court in the Aruna Shanbaug case. Now, after that, in 2018, a significant development has happened in what is called as NGO common cause case. So there was a non-governmental organization which is called as Common Cause. So they filed a petition in front of the Supreme Court. They said that the Supreme Court has to recognize explicitly that the right to live with dignity, which already has been recognized by the Supreme Court, in the same way the NGO common cause case said that the Supreme Court has to recognize right to die with dignity is also a fundamental right implied under Article 21 of the Constitution, which the Supreme Court has accepted. So today, the right to die with dignity is also a fundamental right that is implied under Article 21 of the Constitution. But right to dignity, die with dignity should not be misunderstood as to what is called as suicide. So don't have this misunderstanding, the viewers or the students who are watching this particular lecture. So right to die with dignity is not equivalent to that of suicide. In fact, suicide is a criminal offense. Even today, people who attempt to suicide can be punished. But right to die with dignity is different from what is called as suicide. There is nothing which is called as right to suicide. But there is something which is called as right to die with dignity. So what is the difference between right to die with dignity and probably suicide? In the words of the Supreme Court, is right to die with dignity is in case where the natural death has already commenced. The natural death has already commenced. Say for example, in Aruna Shanbaug case, her natural death has already commenced, and therefore she has entered into a state of life which is not dignified in nature, and through the process of passive euthanasia, we are only helping them in leading to what is called as ending her life. So that is basically what is called as right to die with dignity, where the natural death has already commenced. But whereas in suicide, the natural death of an individual has not commenced. The individuals may artificially end their life. That is not equivalent to what is called as right to die with dignity. So the Supreme Court has well recognized right to die with dignity. That's a different thing from what is called as suicide. But apart from that, what is very important in the NGO common cause case is the Supreme Court has also recognized what is called as the right to execute a living will. So what do you understand by living will? Now, the Supreme Court in this particular case recognized when an individual is active, when suppose let us assume an individual is undergoing a treatment, but the individual knows that in the future there is a possibility that he can become unconscious. He may enter into a state of coma, or he is undergoing a procedure where the outcome is not very clear. In such a case, the individual can write a living will as to what type of medical treatment is to be administered or not to be administered in the future, as to what should be done in the future when he is conscious itself. And therefore, when he is conscious, he can write a will, and later that will can be executed. So that was recognized by the Supreme Court in this particular case. That is in the NGO common cause case. That's basically that every individual can write a living will, especially when they are undergoing a treatment. Along with this, the right to die with dignity has also been recognized as a fundamental right in the NGO common cause case. So you can keep this in your mind. Okay. So today we have seen some of the important applications of the right to life and liberty, or some of the important judgments that has been given by the Supreme Court post the Maneka Gandhi case. So today we have seen three important things. One is right to privacy. We have tried to understand as to what is right to privacy, what are the dimensions of right to privacy, what are the implications of right to privacy, And one such implication is also that why the Supreme Court has declared adultery as not a punishable offense. Although there are a lot of other things related to that, but this is also one of the aspects as to why the Supreme Court has declared adultery as not a punishable offense or a criminal offense. And apart from that, the reason behind why section 377 of IPC, that is the lesbian, gay, bisexual, transgender sex, has been decriminalized today. And then we have also seen the evolution of euthanasia, and what is recognized in India today is only passive euthanasia, not active euthanasia. And what is the development that has happened subsequent to that in the NGO common cause case. These are all very important. It can be asked in your prelims also, especially a simple application or a simple factual questions can be asked in the prelims. But a lot of questions can also be asked in your mains examination when it comes to UPSC examination. All right. So with that, I'll just come to the concluding part. I just wanted you to answer this particular question if you know the answers. And I'm quite sure that if you watch the lecture, it is very easy for you to answer. Consider the following. Statement 1. Right to privacy. Statement 2. Right to die with dignity, euthanasia. Right to clean environment. So which of the above is the right implied under Article 21 of the Constitution? Option A 1 and 2 only. Option B 1 and 3 only. Option C 1 only. Option D all of the above. So if you know the answer, you can put it in the comment box. If you have any queries or any doubts related to this particular session or in general related to the examination, you can reach out to me through my Instagram account or through my Telegram channel, where the IDs for both the things is Babu, BABU _ IAS _ 337. Thank you for watching this particular lecture. And before I wind up, a small request to all of you. If you know someone who is preparing for UPSC examination or other competitive examination, you can refer them these videos and this particular channel, which will be immensely beneficial to them in the long run. Okay. So thank you very much once again. All the very best.